Just 1 second. Okay, everyone, court. My computer is working a little bit slow today. All right, everyone, welcome back to the 2 p.m. session. Welcome back to this fine Monday that I know is a Wednesday on everybody's calendar, but it's been a Monday in the courtroom, but everybody's been very patient. So it's been working out beautifully. Mr. Goss, is your client back?
I'm not sure. Yes, she is. She's there.
All right. Do you have the document?
I have emailed it to you.
Okay, I just received it. Let me print it out. And then we're going to go back on the record on your case. Then we'll take up all the other parties. All right, awesome. All right, is there a prosecutor able to take up Ms. Garcia? The court has already put everything on the record prior, and I know that Nicole had to be in another county. Is there a felony prosecutor available just for the court to give sentence to Ms. Garcia?
Judge, I'm available. It's Hunter.
All right, thank you.
I don't mean to talk to myself in the third person. I am available, Judge.
You know what? Sometimes you have to talk to yourself in the third person. It's okay, because then people will be saying, who's Hunter? And then you'll be like, that's me. Okay.
Oh, this is Nicole's case?
Yes, it is.
Was there anything else about this case, Judge? I can reach out to her real quick.
Oh, no, we've taken care of everything. We put everything on the record. And before we go on the record, Brenda, the only thing we were coming back for is that I wanted a letter from Ms. Garcia's employer showing that they knew that what her charges were. So everything else has been taken care of. I just need to pass sentence.
Okay, and I recall her having no objection to that. So,
all right, the court is calling 2020 CR 7604B. We're back on the record. Can I have parties announced for the record for the state?
Hunter Morris for the state on behalf of Nicole Thornborough.
For the defense?
Jason Goss for the defendant.
And are you Ms. Garcia? You muted, Ms. Garcia.
Yes, Your Honor, sorry.
All right. We were at recess because the defense was going to provide a letter to the court of Ms. Garcia's employer and the fact that Ms. Garcia's employer is aware of these charges and has no objections to Ms. Garcia working for her. The court has received by email the letter. The court has reviewed the letter, and I'm not going to announce the name of the facility on YouTube Live because it has personal information in it. Is there any objection, Mr. Morris? And I know there was no objections from Nicole to the court receiving this letter and reviewing it.
None from the state, Judge.
All right, the court has reviewed the letter. Are we ready for sentencing?
Yes, Your Honor.
Anything you would like to say on behalf of your client, Mr. Goss?
Yes, Your Honor. Just to reiterate what I was talking about earlier, and as Nicole told the court, this is a case where she inadvisedly got fraudulently obtained surgery for a boyfriend that she was in a bad relationship with. He needed surgery and he didn't have any insurance, and so that's what this case is about. They fraudulently obtained that surgery so that he could get his leg fixed or something. But the point is that while in that relationship, Ms. Garcia had a drug problem that she is addressing. The treatment center has been provided to you, and we would ask that she be placed on probation, that the court followed the agreement and allow her to continue with the treatment that she is currently undergoing. It's actually, the program can go up to 4 years, and we would have no objection to the court assessing that kind of treatment over that time period, which we believe would do more benefit to her so that she could continue working than any kind of inpatient treatment. She is currently in the treatment. She is being successful with the treatment. These are charges that happened over 5 years ago, or about 5 years ago. And the conduct and the person that she was with while these charges had occurred is somebody that she's no longer associated with and will not associate with. And as you can see, as part of the plea, she will be cooperating in any prosecution of him later on, if that is necessary and deemed necessary by Ms. Thornbrough.
All right, Ms. Garcia, is there anything you would like to say to the court?
No, Your Honor.
All right, Ms. Garcia, do you have any children?
Yes, ma'am. I have 4
What
children.
what are their ages?
17, 13, 11, and 7.
All right, do they live with you?
3 of them, the 3 younger ones do.
Okay. And if you receive a drug test today, what are the results going to be?
I'm going to be honest with you, I probably will not pass.
Okay, what would you potentially be positive for?
Methamphetamine.
Okay, so how often do you use methamphetamines?
I had been sober for about 2 weeks before Sunday. This past Sunday, my nephew passed away, and I've been having a really hard time with that.
Okay, so if Precision Recovery, I'm gonna have to get some more information on them, but I'm sure they've taught you coping skills for if you're going to use, correct?
Yes, ma'am.
So is there a reason why you didn't call somebody or try to get in touch with somebody if you thought you were going to use?
It was a spur of the moment, ma'am, and I regret it.
All right, this is what the court is going to do. As previously stated, the court found count 1 and count 3. The court found there was sufficient evidence to find you guilty, and the court found you guilty. Those 2 counts were run concurrently together. You do continued treatment with Precision Recovery and Precision Medicine for 2 years. You're going to provide a release so that probation will have information on how you're doing on that program. If you continue to test positive and I don't see improvement with that program, I'm going to consider a different program for you. Do you understand?
Amen.
Sentence you to 4 years in the prison, suspended and probated for 5 years. Restitution to United Healthcare, $9,635.22. $2,000 fine that will be probated. She's do the UA hotline. Are you able to Zoom, Ms. Garcia?
Yes, ma'am.
All right. It's going to be regular Zoom reporting or in person. So if there's an issue with you Zooming, then you're going to have to report in person. And Rebecca, the UA hotline, that will be for 2 months. If there are any other positive UAs consistently, let the court know. So I'm expecting maybe a positive UA the first time, depending on when you do the first test, but after that, there should not be any more positive UAs. If there are positive UAs after that, I'm gonna want a compliance hearing with her. And Mr. Goss, are you gonna stay on as her attorney throughout her probation period? Or no?
No, I do not believe we will be.
Okay. Rebecca, if she tests positive later in the month or at the beginning of June, I'm going to want a compliance hearing with her. The state also states in the plea bargain agreement, they will not file charges of burglary of a building and attempted burglary of a building that are referenced in the case material in the instant case. And the defendant will give full and truthful information about co-defendant Michael Almendarez, Almendarez. There's to be 260 hours of community service restitution. Rebecca, is there, I'm going to want field visits, random, 3 times per month, at least for 3 months, Rebecca. And if she's doing well, then it can go down to 2 times random field visits. And I'm going to do parenting classes. Rebecca, is there anything else she needs?
No, ma'am.
Ms. Garcia, is there anything else you need in order to be successful? I think she's frozen.
No, Your Honor.
All right, thank you.
The
All
judge.
right, Ms. Garcia, I'm sorry, Mr. Morris, did you need anything?
Nothing before we close the record, Judge. I'll ask you after.
All right. Ms. Garcia, I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And before we close the record, the document that the court received from Mr. Goss, do you have any objection to this being part of the evidence in this case?
No, Your Honor.
Right. Then we will submit it as defense exhibit number 1, Brenna. And defense exhibit number 1 is a letter from Ms. Garcia's employer. Any objection, Mr. Morris?
None, Judge.
And Mr. Morris, is that something you wish to say before we close the record?
I'm just taking notes for Ms. Thornborough, Judge. Mr. Almendarez, what was the term that included Michael Almendarez?
On Mr. Almendarez, it states that the defendant, which is Ms. Garcia, will give full and truthful information about the co-defendant Michael Almendarez to include all related conduct surrounding this case, which is the instant case, as well as both burglary of a building and attempted burglary of a building that are referenced in the instant case.
Thank you, Judge.
All right, with that, we'll close the record. Ms. Garcia, good luck to you. You cannot use while you have children. You shouldn't be using at all. Do you understand?
Yes, Your Honor.
All right, I'm going to send you to a breakout room. Probation will go over conditions with you. And Mr. Goss, you can go to the breakout room as well, and you can be excused from the breakout room. Rebecca, are you able to go back to number 1?
I believe so, Judge.
All right, thank you. Thank you all. Thank you for your patience.
Thank you.
All right, Kenneth Eric Baker.
Good afternoon, Judge. I'd like to speak to the state. Last time we were here, they were going to be speaking to the Joe Gonzalez, and I wanted to see if they had an update on whether it was.
All right. Which prosecutor were you working with?
It's David, Judge.
I'm sorry, who?
David?
All right, I sent him to breakout room number 3.
Okay, can you come with us real quick?
Yes, everyone, I
It'll
will
take
be right
No
back.
time at all,
Okay, what is no time at all?
like 0 time. You might have to assign me because I don't see that I'm the co-host. Tom, can you throw me into 3 real quick? Oh, never mind. Robert got it. Thanks.
All right, which inmate is Jose Luis Gomez Gonzalez? If you could raise your hand for me. All right, I'm going to send you to a breakout room with your attorney. I'm going to send you to breakout room number 3. And everyone, just give me a moment. I have to write something in a file. Just 1 second, everyone.
I'm waiting all day, but I.
All right, who are the parties? Are the parties here on Ramsey Gonzalez? Ramsey Gonzalez.
Yes, Your Honor.
Oh, I know you're Mr. Gonzalez. We're waiting for your attorney. Just give us a
Okay,
moment.
Yes, ma'am, Your Honor.
All right, and Teresa Conley?
I'm in the courtroom, Your Honor.
Yes, as soon as I get your paperwork, we'll take your case up.
Thank you.
You're welcome. Juan Aguilera.
Mr. Sanchez is here, Judge.
Okay.
Apparently, what happened is that we had not had a court date. As far as, normally what we do is check on the computer. And we did not have a court date, but then we did get a notice yesterday afternoon. That's the reason we were having troubles as far as finding Mr. Sanchez. He worked late yesterday, but he is on. We were finally able to get a hold of him, and so we've got him. If I could go into a breakout room with him.
All right, just one moment. Brenda, what page is Mr. Sanchez on?
I think he was.
Oh, I found it. Recall. All right, Juan, I'll send you to breakout room number 4. And Mr. Sanchez, I'll send you to number 4. And everyone, just one. All right, Scott Simpkins and then James Toshi. Scott Simpkins, who are you here for?
I'm approaching again, Your Honor. This morning I showed up. I had filed a notice of appearance and a motion to set bond on one of my clients.
Okay, and who would that be? Who is your client?
It's not set today. It's 2018 CR 2310.
No. What's your client's name?
Patrick Cannell.
All right, and what is the cause number again?
2018 CR 2310.
And is it criminal trial division or family violence?
Criminal trial division.
Okay, just give us a moment. All of the prosecutors have the ability to move you to a breakout room. And so when they're ready for you, they'll move you to a breakout room. So if you'll just take note.
Will do, ma'am.
All right, James Toshi.
Hey, Judge. Good afternoon. I'm here on Mary Diaz. It is a bond reduction motion.
Okay, is she criminal trial division or family violence?
It's family violence, Judge.
Okay, the prosecutors have the ability to request you to go to another room. So let me make them a co-host and they will request for you to go to a breakout room. So I think the prosecutors we have here are Joe Ray and we also have David Martin. So one of them will be asking you to go to a breakout room. All right, Ross Rodriguez, you're here on Mr. Gonzalez?
Yes, Your Honor. We've, I believe, completed all the plea paperwork that's for today.
Yes. Who is the prosecutor who's available for this plea?
That was David, who I was talking to, Judge. Also, Hunter was in there.
Okay.
I can step in and do it, Judge.
All right. And David Martin, are you available to discuss the bond reduction with James Toshi?
Yeah. What room do you go to?
Oh, no. You can move him to whatever room you want to move him to. If not, I'll do it. I'll move you guys to number 5.
Yeah. If you could move us to 5.
Yes. All right, court is calling 2019 CR 9380, State of Texas versus Ramsey Gonzalez. If I could have parties announced for the record, please, for the state.
Joe Ray Garcia.
For the defense.
Jose Rodriguez.
All right, and are you Mr. Gonzalez?
Yes, ma'am, Your Honor.
All right, everyone, just give me one moment. I've just received a letter that's marked urgent. All right, we're back on the record. We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No objection, Your Honor.
Mr. Gonzalez, I'm showing you what's entitled Defendant's Consent to Plea by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am, I did, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am, I did, Your Honor.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, ma'am, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
The state waives the repeater enhancement paragraph.
Any objection?
There's no objection, Your Honor.
Mr. Gonzalez, I'm going to show you a document entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, ma'am, I did, Your Honor.
Did you understand what you're charged with is assault family second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, Your Honor.
Did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine any witnesses the state would call them, the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand by entering this plea bargain agreement you were giving up these rights?
Yes, ma'am, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am, Your Honor.
Are you a U.S. citizen?
Yes, ma'am, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. The state will make no recommendation on your application for deferred adjudication or community supervision. Rebecca, this is cause number 2019 CR 9380. It's Ramsey Gonzalez. The offense is assault family second.
Thank you.
All right, so I'll start back over with the plea bargain agreement so that Ms. Reyes will have it. So punishment is to be assessed at 5 years in the prison. The state will remain silent on your application for deferred adjudication or community supervision. State will take in consideration NIMAC number 585260 and 599806. There's an affirmative finding of family violence, a MIC-MILF evaluation, $100 to an approved family violence center. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand?
Yes, ma'am, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am, Your Honor.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am, Your Honor.
All right, we've lost your video, Mr. Gonzalez.
They're going to fix it, Your Honor. I apologize.
Thank you. Brenda, it's still Monday on a Wednesday. All right. Mr. Gonzalez,
Yes, ma'am, Your Honor.
showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it, and did you electronically sign it in both places?
Yes, ma'am, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, Your Honor.
Counsel, have there been any such motions?
No, Your Honor, there have not.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that you have no contact with Ramsey Bustamante, R-A-M-S-E-Y, last name G-U-S-T-A-M-A-N-T-E. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's plea.
State offers State's Exhibit 1 and all its attachments.
Any objections? Mr. Gonzalez, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Norma, can I have a date for this to come back for sentencing?
Yes, ma'am. They can come back on June 30th.
All right. And that'll be at 9 a.m. I'm going to order a MIC-MILF evaluation while in custody. Defense, are there any drug issues with your client?
No, Your Honor.
All right, well, we'll do a tap evaluation just in case. And Rebecca, that will take place while he's in custody. If there's nothing else, we'll close the hearing. Mr. Gonzalez, I'm going to send you to a breakout room. Probation will speak with you. I will base my decision on your application upon a report that I received from probation and any other evidence that's presented to me.
Your Honor.
So you're welcome. I'm going to send you to breakout room number 5.
Yes, ma'am, Your Honor.
And Mr. Rodriguez, I'll send you to 5, but you, of course, are excused.
Yes, Your Honor.
And Rebecca, I'm trying to find which room you're in.
I can move to 5, Judge.
All right, thank you. All right, anyone else ready? Juan Aguilera, you're here from the morning. So what's happening with Mr. Hector
I talked to my
Sanchez?
client, if I could talk to Mr. Nesbitt, if he's available.
I think Tom is available. Okay, I'll send you to breakout room number 1.
Okay.
All right, James Barrett, who are you here for?
I can see myself. My hair looks so nice. You can't.
Unmute myself. Here I am. Oh yeah, I had a matter that was called by the court to on a bond violation. She's set for this day on violating conditions of bond, namely not reporting. You've asked her to come in today. I've called around, talked to her sister. The sister has told me that she hasn't found her sister for 3 days, and she hasn't seen her sister for 3 days. Her phone is off. She hasn't been to work for as of. All
right, let's do this. Let's get this on the record.
Sure.
All right. Yes, Hunter, you raised your hand.
I'm available.
Okay, thank you. I like the hand raising. All right, the court is going to call 2021 CR 0386, State of Texas versus April Donato. We're going to have parties announced for the record for the state.
Hunter Morris for the state.
For the defense.
James Merritt, attorney appointed by the court for defendant.
All right. We're proceeding by video because of the pandemic. Any objections from the state?
None from the state, Judge.
Any objections from the defense?
No, Your Honor.
All right. We're here on a violation report from pretrial services on your client. Mr. Myrick, have you had a chance to review that document?
Yes, I have.
State, are you ready to proceed?
Yes, Judge.
All right, Mr. Meyer, the complaint that the court has received is that they have not had any contact with your client. It states that they made several attempts. They've called all the numbers that are listed. I'm not going to state the phone numbers on the record because we're live on YouTube, but they've tried 4 different numbers. Have you had a chance to get in touch with your client, or were you able to get in touch with your client for this hearing?
Well, prior to this hearing, the last time I had spoken to my client, Miss Marie Donato, was the May 13th, and that was the day in which she had a trial setting. And after that time, I have not had any contact with her. I was given a call on the May 14th. What was it? Well, the pretrial service office did call my office trying to find her whereabouts, to which I responded, I talked to him and I said, well, she was just in court the other day. And I gave him what information I had, which was the numbers that he called. Recently, as I got the VR earlier this week, I had tried to call Ms. Donato several times from the resources that I had. My primary resource was the sister, who has always been invested in her case. And she's always been able to find her at previous times, but this time She has related to me that she has not seen her for the past 3 days. She hasn't reported to work. Her phone is off, and she has not been residing at her home. Prior to being at her home, she was at a Haven for Hope for some period. That's where last I remember getting mostly in consistent contact. But since she's left at Haven for Hope, it's been very spotty contact with her. But as far as this week is concerned, since Monday to today, I have not gotten in contact with her, nor have her relatives been able to track her down.
Okay. State?
Judge, the state would ask that the bond be forfeited and a warrant be issued.
All right, I'm going to grant the state's motion, Mr. Myrick. If you're able to get in touch with your client, because the court is concerned if nobody's had any contact with her. I'll note that this is the 187th first violation report from your client, but her companion case out of County Court 7, it's the 4th violation report on that case, and that is an assault, bodily injury, family, or household. And what she is on bond for under this court is a burglary habitation force. So I'm going to grant the state's request. If you are able to get in contact with your client and she presents herself, I will reconsider. But she will be remanded without bond, and I'll issue the bond forfeiture.
Okay, I'll track her down. Thank you, Judge.
All right, thank you so much for coming in. Have a good day.
Thank you.
All right, James Toshi, you're here on Mary Diaz.
Yes, ma'am.
All right, is there an agreement or no?
No, Judge, there is unfortunately no agreement.
Okay, who's the prosecutor you were speaking with?
David Martin.
All right, David Martin, are you ready to proceed on this?
Yes.
All right, are there going to be witnesses or just argument?
I have one witness, Judge, and I will be brief.
All right, no problem. Oh, I mean, you can, we are here, as I tell everybody, from 9 to 5. And if we need to go into the next day, we will go into the next day. It's just that we won't, well, there have been times where we've stayed till midnight.
Well, I can.
Not that late.
I can start by asking her about her childhood if you'd like.
Well, I will tell you this, Brenna. I've had a case before as a defense attorney. We were here till midnight, and that's when I learned that TGI Fridays, which I don't know if it's still around anymore, they're open till midnight because we were starving. And no one would share food with us. And you can ask, Celeste Ramirez was my co-counsel on that case. All right. And I'm sure James.
And Judge,
yes.
I'm back from a breakout room with Tom. If you could put me in a breakout room with Mr. Hector Sanchez.
All right.
We may be able to resolve it.
Okay, let me see what room you were in. Number 1. Mr. Sanchez, could you go to breakout room number 5, please?
And Your Honor, real quick, I conferred with state. May I be excused?
Who is Scott?
Scott.
Oh, so your case is not being heard?
Not today, Your Honor. We've come to an agreement. I just got to get it done with my client.
Okay, all right, thank you.
Thank you.
And when you say come to an agreement, is this the agreement on bond or something else?
An agreement to resolve the MTR.
All right, well, let's do this. Let me put you in a breakout room with Miss Ferguson. And Norma Ferguson, if you could go to a breakout room, please.
Yes, ma'am.
And speak with Mr. Simpkins. He's in breakout room number 2. And Mr. Simpkins, if you could go back to 2.
Thank you, Your Honor. May I be excused from the breakout room afterwards?
Yes.
Thank you.
Court is calling 2020 CR 11865, State of Texas versus Mary Jessie Diaz. Could I have parties announced for the record for the state?
Still muted. David Martin.
For the defense?
James Tochi, Judge.
And are you Mary Diaz?
Yes, Your Honor.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, ma'am.
Ms. Diaz, do you have any objection to this hearing taking place by video?
No, ma'am.
All right, defense has filed a motion seeking a bond reduction. State, have you reviewed the motion and are you prepared to proceed?
Yes.
All right, defense is your motion. You may proceed.
Thank you, Judge. And I probably should have told you this. I believe in the waiting room is Priscilla Diaz, my witness. I saw her here earlier.
Yes, sir. Also, I know that they said, couldn't we
Okay,
fight it like?
Ms. Diaz, are you
with the fact that
speaking?
They have to prove that I actually.
Okay,
lived
what I'm
there,
gonna do,
you
Ms.
know?
Diaz, if you can mute and
'Cause-
unmute yourself for me, please. Thank you. And whenever your attorney needs to speak to you or there's something you want to get somebody attention, if you'll just raise your hand, I'll keep an eye on you, okay? All right, and then Priscilla Diaz, I need you to unmute yourself and show your video. All right, defense, call your first witness.
Thank you, Judge. I would like the court to hear from Ms. Diaz, Priscilla Diaz, Judge.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
You can lower your hand, and if you could state your name for the record, please.
Priscilla Diaz.
All right, defense.
Thank you, Judge. Ms. Diaz, could you tell Judge Boyd how you know Mary Diaz?
That's my sister.
Okay. How many siblings do you and Mary have other than the two of you?
We have 4 brothers and 3 sisters
Big family. And where are you from? Where's the family from?
from San Antonio.
All right. So today we're here to talk about the bond. And of course, we're asking Judge Boyd to consider lowering the bond. Let me ask you this question. Do you know what the bond is currently set at?
Yeah.
Okay. What is it?
The 250,000.
Okay, now is that a bond amount that in its current amount that you and your family members believe you can afford?
No.
Okay. Have you or your mother or your father or any of your family members actually been in contact with bond companies?
No.
Okay. You have not made any, you haven't called any bond companies?
Like we've had one a long time ago when this first happened, but other than that, no.
Okay. And that bonding company that you called, we did talk about that. How do you know how much money they will want to bond her out?
I believe they asked for 25,000.
Okay. All right, let's talk a little bit about Mary's family. Let's talk about Mary. Does Mary have a lot of money?
No.
What kind of work does she do?
She don't work.
Okay. And how about her mother? Does she own a significant amount of property or have a significant amount of financial holdings?
No.
Okay. How about her father?
No.
How about you?
No.
Okay. Are there any homes that anyone owns that could possibly be put up for sale that somehow could earn the proceeds to put toward that bond?
No.
And your other siblings, the 5 others, are they aware that Mary's in jail on a $250,000 bond?
Yes.
Have they been contacted? Have you been trying to pool your resources and money?
No.
Do your other siblings, do they own homes and have significant amounts of financial holdings to be able to
No.
secure the bond?
No.
Okay. The bond in its current amount, is there any way possible that you or any of your family members could afford that bond?
No, sir.
Okay. Okay. Do you know if your mother, I thought when we had met, your mom had indicated she had contacted several. Do you know, has your mom contacted other bonding companies than the one you're aware of?
Not that I know of.
Okay. All right, Priscilla, that's all the questions I have for you, Judge. I don't have any further questions, and I'll pass the witness.
State? Brenda, you can't tell, but my eyebrows are lifting. I'm like, state? Did you see the
Sorry, I
eyebrow
muted
go
myself.
up?
No, I was looking at my computer. I can imagine it though. All right. Okay, Priscilla, do you remember way back in 2004 when your sister was charged with theft $50 to $500 in County Court 11?
No.
You don't? Okay. Has she ever? She's been to jail before, though, right?
Yes.
Okay. And back in 2004, did she ever contact you about concerns about missing court dates?
I mean, if she did, I don't think I remember.
You don't remember? Okay. So back in August of 2004, do you recall if she ever talked with you about failing to appear in court and they forfeited her bond and she got rearrested?
No.
No? Okay. What about in 2006? Do you remember her having any discussion with you about failing to appear for court and they forfeited her bond in 2006?
2006. No.
No? Okay. What about in 2007 when she picked up an MTR and failed to appear and they forfeited her bond? Did she contact you, ask you for help about that?
No.
I think we lost David.
You know why we lost him? Because today is Monday on a Wednesday, right?
It was his questions, Judge. They were that bad.
All right, and while we wait for that, the court still does not have any paperwork for Mr. Hill. Does anyone know, has the paperwork been signed by Mr. Hill? All right, everyone.
Judge, while we're waiting for Mr. Martin to get back on Hector Sanchez.
Yes.
Mr. Nisbet has offered a pretrial diversion. And so what we're going to do is we could have perhaps a week to get the paperwork done. There's going to be some restitution, upfront restitution in order to be for Mr. Nisbet to offer that. So that's what we could get a week to come up with the money, get the application done and everything.
All right, Norma, for the update on the pretrial diversion on Mr. Hector Gonzalez Sanchez.
Yes, ma'am.
I mean, we usually recall these back in 30 days. Is that correct, Ms. Ferguson?
Yes, ma'am.
Whatever's convenient for the court. I think.
All right.
I was trying to get on the DA's webpage to try to download the copy, and it kept kicking me out. So it may take a little while.
Well, because today is Monday, even though it's Wednesday. That's why
it is. That's yeah, because I was anticipating being through by this time this morning.
No, not on a Monday. All right. Norma, what's a 30-day date for Mr. Sanchez?
June. We can come back on June 29th, Judge.
All right, we'll be back on June 29th.
Okay. Thank you, ma'am. May I be excused?
You. Yes, you and your client are excused.
Thank you.
Juan,
Yes, ma'am.
when you leave, tell our story. All
Trying to
right.
remember.
You have to tell the story when you leave. That's what people always say. Be sure and tell people what you saw here today.
Okay, okay.
That's another movie reference. That's why I need Jordan here.
I've been watching all these shootings in San Jose.
Mhm. Wow.
When we travel to San Francisco area, we usually fly to San Jose. So it's actually all that in that area. So it's kind of scary.
Well, hey, safe travels.
Excuse me, I have a question.
Excuse me. Don't interrupt. Just give me a moment.
Okay,
All right.
may we be excused, ma'am?
Yes, Mr.
Thank you.
Aguilera, you and your client are excused. All right, we're going to go back on the record on 2020 CR 11865. Mr. Martin, you have made it back with us and you were asking questions. And again, Brenda, my eyebrow goes up. Whoa.
I think he's having computer issues, Judge. He's appears to be frozen.
No, sometimes David just stands still like that. So we have to wait a good 2 minutes and then we can see if he's frozen or not. All righty.
It's Teresa Conley. Can I jump in?
Yes.
Before I left, I'm in the courtroom. Before I left my office, it said everything completed. The client was having trouble getting on. He's on his way down to the courtroom too.
Okay, awesome. We will be here.
Thank you.
All right, thank you. Brenna, I think I put midnight into the universe, so now it's happening. I take it back.
Yes.
Your witness is on line 4. She wants me to email her copies.
Oh, Brenna, did you receive the email I sent?
I was just about to say that. Yes, I did. Thank you.
All right, thank you.
Judge, what is going on with Anidria Flowers?
And who would that be?
It's a murder case that was awaiting a competency, like.
Oh, let me talk to you. Yes, that is scheduled for a jury trial on the competency issue.
Oh my goodness.
So, but that's coming up shortly. So that's what's happening with that.
Okay.
He was found competent and
disagreed.
No. Anton requested a jury trial. So that's what's happening with that.
Okay.
You know, Brenna, when I first came here, they still had me using a dot matrix printer. I'm like, what is this? Okay. All right. David Martin is back.
Okay. Back from the Twilight Zone.
Awesome.
Yeah.
Let me.
I had to switch devices. That might make it easier.
Okay. Awesome.
So
we are back on the record in 2020 CR 11865. State of Texas versus Mary Jesse Diaz. And we were on state's cross-examination of defense witness Priscilla Diaz. State?
Yeah, Brennan can just tell me where I got dropped.
1 second. What about in 2007 when she picked up an MTR and failed to appear and they were forfeit?
Okay.
Yeah.
Okay. So in 2007, did your sister contact you about missing court and having her bond forfeited and needing help?
No.
No? All right. I have no more questions, Judge.
All right, anything from the defense? Oh, we can't hear you, Mr. Tochi.
Oh, I'm sorry, Judge. I had my mic off. No, I have no further questions, Judge.
All right, any other witnesses defense?
No, Judge, that's it.
All right, state, any witnesses or evidence?
I have no witnesses, but I do have, and I'm trying to pull it up. State's Exhibit 1 will be the prosecution guide for this case that I will email to the court reporter, and to Mr. Tochi. Assuming my computer doesn't explode on me in the next 10 seconds. And then I'm not sure the best way that the court would want to do this. I could make it into a PDF and send it over, but I would ask the court to take judicial notice of County Court case number 882138, which is the case I was asking questions about, where there were 3 bond forfeitures for Ms. Diaz.
All right.
And that's all I have. I would rest.
Okay, as soon as that document comes through, defense, are you going to have any objections to that document? Have you had a chance to review it?
I have seen her history, Judge, on some prior arrests that she had, so no. And of course, I have seen the prosecution guide, so no, ma'am, no objections to that.
All right, then State's Exhibit 1, the prosecution guide is admitted. It has just come through the court's email, and the court is reviewing that. And just give the court one moment, please.
Are you going? Damn, what kind of hook are you on here, Stacy? I'm on the record.
All right, the court has reviewed State's Exhibit number 1. If there are no further witnesses or evidence, then the court will hear argument. Defense, it's your motion.
Judge, the only question I had is, did you want me to send the, I guess, the events page as best I can from that county court case number, or can you roll through CGIS and see it?
Well, if it's something that you want me to review for purposes of the record, it'll have to be something that is sent to me.
Okay.
And printed out so that the defense will have a copy of it as well.
Okay, I just made the PDF, so I'll send that to you.
All right, and what exhibit will that be listed as? Is that
It'll
listed
be
as?
states number 2.
Okay.
All right, and it should be coming.
Okay, let me check my email. All right, any objection to states exhibit number 2?
No, ma'am.
All right, the court has reviewed states exhibit number 2. If there is no other evidence to be presented, then the court will hear argument.
So, Judge, I mean, there are a lot of different factors to consider in arriving at what an appropriate bond is. To me, $250,000 is not a ridiculously high bond for the allegation. However, I do find it to be pretty darn high, even though the allegation is murder. I'll start with some of the factors that I want you to consider is her history. She does have some arrests in her past. However, the only criminal history that she has is a misdemeanor theft conviction from 2004, some 17 years ago. And looking through her history, I do not find that she has any other convictions. So obviously, I believe that factor should weigh very, very heavily in Miss Diaz's favor. The other arrests were either dismissed or closed out or rejected and didn't result in any convictions. And they all appear to be antiquated. Now, showing up to court is important. I'm not making light of that in any way. I can't speak to a bond forfeiture from 17 years ago, but she was probably 17 years old at that time and, probably not as responsible. So I'm not telling you not to consider that, but her history certainly weighs in her favor. The only other thing I can tell you, Judge, and I should have sent you this, and I can still send you this. I had a bond hearing before Judge Carruthers last week, and what I did was I had district court admin. I had them pull every single murder bond from people that are incarcerated right now. And as of 2 weeks ago, it was 144 people sitting in the Bexar County Jail accused of murder. This does not include bond cases. And one thing I can tell you, and again, I don't mind sending you the numbers, is the vast majority, almost 100 of those 144 were either set between 100 and 150. Some capital murder bonds were set at the current amount of 250, which is where Ms. Diaz is. Those are capital murder bonds. And of course, all cases are different and all histories are different. I can't speak to that, but what I can tell you is I know the court has been a prosecutor, has been a defense attorney, and now a judge for quite some time. And I know that the court knows that in general, murder bonds for individuals that lack a significant amount of criminal history or none at all, they generally hover in that 100 to 150. Now, some cases are different than others, and I know you've read the prosecution guide. I would just remind you, this is just an allegation, Judge. I do not see any good reason why her bond sits at the amount that it's at. This should not be a $250,000 bond. Her bond should be like the vast majority of other murder bonds, right at 100, no more than 150. Her family truly cannot afford this bond in its current amount.
That's how much money it is. Murder?
That's another factor that I would like for the court to consider. So when you kind of take everything together, her bond, I will say it is kind of ridiculously high. And I'm not making light of any allegations. I know the complainant's family is here. It has nothing to do with them or their family member, but I'm just asking the court to do the right thing and set the bond in the appropriate amount.
All right, State.
Well, Judge, just based on State's Exhibit number 1, we feel the bond is an appropriate amount. Plus, State's Exhibit 2 shows, whenever it was, facing the maximum of 180 days in a Bexar County jail, Ms. Diaz failed to appear to court 3 times. Obviously, the punishment range for a murder is significantly higher than that. So to ensure her appearance in court and the safety of the community, we would ask that the court leave the bond where it's at.
All right, defense, this was your motion, so I give you last argument.
Again, what happened 17 years ago on a misdemeanor, Judge, I don't think should rule the day. She has a GPS on her that is already has been made an order of the court, and that is a full GPS. And so you're going to know exactly where she is. And of course, in my discussions with her and her family, she's going to show up to court. So if that is a concern, let me try to allay your fears that she's just going to pop that thing off and take off. I assure you she will not. So in response, Judge, that's all I have.
All right. The court will deny the motion. Is there anything else from either side?
No, Judge.
Not for me, Judge.
All right. And with regards to her case, Mr. Toshi, have you received all the discovery, or are there discovery issues that are coming up on this case?
Yes, ma'am. I still think we were here just last week, I think, on a setting, and those issues are still lingering. So admittedly, it's only been a week, and I'm not sure what Mr. Martin has been able to verify or do on his end, but yeah, there are a volume of videos that I still have yet to receive.
All right, Mr. Martin, when do you expect to have those to Mr. Toshi? Or is this something that's going to be sent over the computer, or something he needs to physically pick up with an external drive?
Yeah, I can drop it by his office. It was a disk that had a whole bunch of PDF files that some of them wouldn't open or were corrupt. So on Friday, when I go to the office to do some other things, that's on my list to get those either on a disk where they open or print them out, and I can drop them at his office on Friday.
Okay. Norma, can you recall this case in 3 weeks, just to make sure that Mr. Toshi has received all of the evidence?
Judge,
Yes.
I will not be here in 3 weeks. From the 16th, I believe, through the 29th, I have blocked off some time.
Okay.
I think I'm back on the 29th or 30th of June.
All right, Norma, can you recall this for June 30th?
Yes, ma'am.
For discovery. All right, so we'll put it down for June 30 for discovery, Mr. Toshi.
Very well.
All right, do you need to speak with your client?
Real briefly, Judge, yes.
And then after you speak with her, if you'll come back, bring her back to the main room, because she has to be excused from the main room.
Okay.
All right, I'll send you to breakout room number 1.
Thank you, Judge.
All right, anyone else ready? And is this April Donato? Norma, you want to see if you can call April Donato's attorney back?
Judge, this is Teresa Conley. We are ready, and Mr. Hill's here.
All right, Teresa, the only problem is I don't have any paperwork. So once I receive the plea paperwork.
Lupe's looking for it. I just asked him when he came in the courtroom.
Okay.
What?
Yeah, we're going out there right now to swear him in. We should be ready after that.
Thank you. And then normal April Donato's attorney needs to be here.
Yes, ma'am. I'm on hold.
All right, thank you.
Judge, do you have a moment, Mrs. Hunter?
Yes.
We have a setting tomorrow for a Jimmy James Wood. It's on an assault elderly. The offer in that case is for time, and the attorney just wants to make sure it's fine if this person shows up in person for that.
Yes.
Okay, I didn't know if we needed special permission or anything.
Oh, no, he can. That's one of our in-person days.
Perfect. Thank you, Judge.
You're welcome. Everyone, just give me a moment.
Just getting after. Okay. I saw the construction workers. Oh, it's a mess, isn't it? I know, yeah.
All right, who's the prosecutor on this case? With Mr. Hill?
Hunter Morris, Judge.
All right, Mr. Myrick, while your client, Ms. Donato, showed up, would you like to confer with the state on that case?
Yes, yes, I will.
Randy here in mine.
All right, if there's a prosecutor available to confer with Mr. Myrick, if you could send him to a breakout room. It's on April Donato. And to the clerks in the back, could I please have the file back on April Donato? She's appeared. All right, the court is calling 2021 CR 4514, State of Texas versus Patrick Hill. Could I have parties announced for the record, please, for the state?
Hunter Morris for the state.
For the defense?
Teresa Conley for Mr. Hill.
And are you Mr. Hill?
Yes, ma'am.
We're proceeding by video because of the pandemic. The court will note for the record that the defense and the defendant, Mr. Hill, are in the courtroom. This is one of the in-person days for the court. But Mr. Hill, I'm going to show you a document entitled Defendant's Consent to Appear by Video. Did you review that with your attorney? Did you understand it? And
Yes,
did you
ma'am.
electronically sign it?
I electronically signed it and my attorney did go over it with me.
All right, the court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor, and I electronically signed it.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hill, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, I do.
State, are you proceeding on the indictment as presented?
Judge, the state would waive the repeat offender allegation proceeding on counts 1 and 2.
Any objections to the waivers?
No objection, Your Honor.
All right, Mr. Hill, I'm showing you what's entitled. Just one moment. Can I see you guys in a breakout room, please?
Yes, Judge.
All right. I can see you all in breakout room number 1. So courtroom, I'm going to send you to breakout room number 1.
Thank you, Your Honor.
Yes. And Hunter, if you'll meet me in number 1.
May I ask a question? Hello?
No, ma'am, you need to hold on.
Okay, thank you.
All righty, Mr. Myrick, you've had a chance to confer on April Donato.
Sorry, Judge, I hadn't because I didn't get the breakout room assignment. I don't think I did. I didn't see the breakout room assignment.
Okay,
But-
just give us a moment. We'll take care of that.
No worries.
All right, Mr. Morris.
There's the resolution, Judge. Whenever the
Okay.
court is ready to go back on the record.
All right, let's go back on the record. Oh, could you have them to leave?
We need the courtroom to leave room.
Let me go there. Oh, yay. All right, we're back on the record in 2021 CR 4514. Had a discussion in the breakout room with defense counsel and state. And is there a resolution, state?
Yes, Judge. Along with the repeat enhancement, the state would waive count 2, proceed exclusively on count 1, evading vehicle. The state would also ask there be a material change made to the plea agreement itself. The plea agreement states that the plea would be for counts 1 and 2, and the state would change that to just count 1.
No objection, Your Honor.
All right, then, Mr. Hill, you understand that the state is only proceeding on count 1?
Yes, Your Honor.
All right. Oh, and to the courtroom, could you adjust the camera? Or maybe Mr. Hill has grown several inches since we did the breakout room. I don't know. It's a Monday. All right. Thank you. All right, Mr. Hill, I'm going to show you a document entitled Court's Admonishment and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, Your Honor, and yes, I electronically signed it.
All right, you understand the state is proceeding on count 1 only. That's evading arrest, detention with a vehicle. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, I did, Your Honor.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, I did, Your Honor.
Okay, it seems to me that somebody needs a mask on. Now, I do know that in the courtrooms, I require that masks be worn. I'm not a medical doctor. I do try to protect everyone who appears in my purview because I don't want anybody saying that you caught something from the 187 District Court. But there's a lot of coughing going on. And as people always say, when people cough, you give them that side eye where you're just like, and I hear people coughing and nobody's saying it's not COVID.
Judge Rangel is. He gave me a test, Your Honor. I have bronchial asthma.
Okay, awesome. Thank you. I'm glad that's on the record. So
it is.
Mr. Hill, you are safe.
Thank you, Your Honor.
Thank you for letting me know, Ms. Conley.
Half the time. I sound like a frog.
Ah, that's okay. Well, Kermit was a nice guy.
Yeah.
But it's not.
Please.
Excuse me, it's not COVID.
Okay.
Frankly, these rugs are so dirty. They're so filthy. I'm sorry, they never vacuum them.
Oh, well, I will say this, Teresa Conley, maybe if you would have said that yesterday, you would have been correct, but they just put down new carpet. So nobody is allowed to drink in that courtroom. So we are back on the record.
Right.
So counsel, has your client been able to provide you with any defenses to this offense?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hill, that mask works better if it's over your nose.
Sorry.
All right. Mr. Hill, has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, I am, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, I did, Your Honor.
According to the plea bargain agreement, state is proceeding on count 1 only. Punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. There's no application for deferred adjudication, and the state recommends community supervision. There's to be restitution, if any, to Deborah Baker, D-E-B-O-R-A-H. Do you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, it is, Your Honor. There's just an application for probation.
State, is that the plea bargain agreement?
It is, Judge.
Mr. Hill, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 120 hours of community service restitution, DWI education, DWI victim impact panel, and defensive driving course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, I did, Your Honor.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
Judge, I believe the agreement with Ms. Connolly was for a plea of guilty.
It is.
Okay, my apologies. I apologize, Your Honor. Guilty.
All right. State any evidence to support the defendant's guilty plea.
State offer states one of the attachments, Judge.
Any objections?
No objection. They've been reviewed.
Mr. Hill, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes and yes, Your Honor.
Ken, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, I did, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, please.
Anything you wish to say on behalf of your client?
Your Honor, just in terms of this plea, and that's how I got to know him, really. He is a very polite man, extremely polite. He obviously, there was a repeater count, and I questioned him about that, and he said, "I'm not the same man that I was 10 years ago." Indeed, he's not. He has a wife. He has an 8-year-old son. his son is very important to him. Yesterday we reset because he had a child up at school. He got somebody else to take care of her today. He seems dedicated to his family and he's determined to make the best of this. The terms are very difficult, I think, on this probation. There's a lot he has to do, but he's willing to do it and make the sacrifices that he has to make to do it. So I don't think you'll be sorry for this. I don't think you'll ever see him again.
All right. In state, why is there conditions that are usually placed for driving while intoxicated? Does he have a DWI case?
Pending case, Judge.
He has a pending DWI case?
Yes, Judge, and that's part of this plea agreement. That case be resolved also.
So is that case being taken in consideration, or is he still going to have to plead for that?
He'll end up pleading, Judge, but it's for a judgment satisfied.
Is that correct, counsel?
Yes, it is, but I wasn't sure how we were going to deal with it actually. Are we going to be pleading it in here or?
No, it will not be pled in here.
Okay, thank you. It's in County Court 14, Your Honor.
I 100%, well, not 100%, I just 50% don't feel comfortable giving him DWI conviction, conditions when he is pleading to a DWI in another court and taking a conviction on that case and doing a judgment satisfied. Was part of the plea bargain agreement to this case is that you all would give him a judgment satisfied if he agreed to do these DWI classes, because the DWI education course and the DWI victim impact panel and defensive driving course, that's outside your plea bargain agreement. It's below the line. I can understand doing the defensive driving course, but I'm trying to figure out why I should give him DWI education and victim impact panel when to get his license, he's going to have to do the DWI education course on his own anyway.
Because those were part of the plea agreement, to my understanding, but if this court likes, it could run them concurrent with that case, just so there's nothing unnecessary done.
Okay. So then what I'll do is 5 years probation, suspended and probated for 5 years.
Thank you.
$1,500 fine, that will be probated. Restitution to Deborah Baker. 120 hours community service restitution. Mr. Hill, are you employed?
Oh, yes, Your Honor.
And what do you do?
At the moment, I'm landscaping.
How far did you go in school?
I got my high school diploma.
Okay, awesome. So what are you planning on doing with the rest of your life?
Honestly, the type of person I am is, I can't say exactly what I want to do. I just know when I put my mind to one thing, I'm really good at it. So I guess you could say entrepreneur. I know I want to work for myself, and I know.
How old are you?
I'm 29 years old.
All right, so the days of trying to find yourself, or where you have that thing where you take a year off to go find yourself, those are past. They pass when you are your age and when you have a child to support. So you've got to start making decisions. I'm going to say proof of employment within 15 days, no employment as a home health care provider or where you supervise minors. And there will be 200 hours of community service restitution. That will be waived if you complete some sort of trade school or some higher level of education. Regular reporting. Are you able to report by Zoom?
Yes, Your Honor.
Okay, by Zoom or in person. If you're drug tested today, what are the results going to be?
I will be dirty for marijuana.
And anything else?
No, Your Honor.
You better stop using marijuana. Do you understand?
Yes, Your Honor.
I'm going to want UAs, Rebecca, test for levels. And that'll be regular UAs. random field visits once per month. Defensive driving course. And you do need the DWI education course in order to get your driver's license back. So I'll say DWI education course. And I'll go ahead and do DWI victim impact panel, because I hope you know that Miss Baker was enjoying her life, watching television or whatever she was doing when a car interrupted her tranquility. Do you understand? While she was inside our home.
100%, yes, ma'am.
All right, Rebecca, is there anything else he needs?
No, ma'am. And just to clarify, it's 200 hours or the 120?
No, I'm going to do 200 hours.
Okay.
So that will encourage you, Mr. Hill. You can either do the 200 hours or do something to better yourself, right?
Yes, ma'am.
And actually, you know what? I'm going to try this. They have a program, Mr. Hill. Just one second, Rebecca. This is a new program that I heard about. And this program will pay you, if you qualify, it will pay you $15 an hour to improve yourself and potentially get you in class. Let me just find the name of the program. Just one second.
It's good.
And I think
you lean against the wall.
So what happened was I'm walking out.
Excuse me. Tell Jordan that we miss him, but we're in a hearing. Okay, let me find the name of that program. Just one second. One second. I know I have it here.
Scram, preach on whatever.
Oh, yes.
All right, everyone, just give me a moment, please.
No, it's a-
Yeah, no.
All right, it's called Turning Point is the name of the program. And Rebecca, so I'm going to want him to apply for Turning Point.
Okay.
And the presentation I heard, it's a great program. And so I'm going to add Turning Point. And Mr. Hill, it is not to punish you, but I think this is something that will really help you.
Okay.
So I'm going to add Turning Point as a condition.
Judge, is that with the reentry program?
Yes. And the name of the person to contact Rebecca is Lenora Walker.
Thank you, Judge.
All right, and that will help get you on track. So Rebecca, to add to his conditions, we're going to add Turning Point. And if he successfully completes Turning Point, that will be in lieu of his community service hours.
Thank you very much, Norma.
Oh, you're welcome.
He still has
Is
Scram. Can you take that off the requirement for Scram?
Let him give me some positive, some negative UAs before I do that. So once he provides me with some negative UAs, then I will consider removing that. So it's completely up to him. If he continues to smoke marijuana, one
You don't
may
have to-
end up getting revoked. So you got to make a decision. Is marijuana more important than your freedom? More important than you being on scram? So once he provides a history of negative UAs, I'll reconsider that.
Thank you, Your Honor.
You're welcome. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, I'm going to send you to a breakout room. Rebecca, the probation officer, will go over conditions with you.
Excuse me, Judge, before we go, since he already has Scram, do you want to make Scram part of his conditions? So that way probation can continue, because if he has Scram on, it's more than likely pretrials supervising that right now.
All right, yes, let's continue with Scram.
Okay.
And then Mr. Hill,
Yes, Your Honor.
if you're successful on that for at least a month with no positive UAs, then I'll reconsider, okay?
Okay.
All right, do you have any questions about anything?
No, ma'am.
All right, Mr. Hill, you're going to be the first person that I am sending to this program, Turning Point. So I want you to be the shining star, okay?
Yes, ma'am. Thank you, Your Honor.
All right, you're welcome. I'm going to send you to breakout room number 1.
Okay.
Thank you.
Let me find the courtroom. Yes, courtroom. If you could go back to number 1, please.
Sheriff's doing all this, thank God.
Yeah, sure. And Rebecca, if you could go to number 1, please.
Yes, ma'am.
I don't know, why is this girl sitting on the floor with her legs gapped? Yeah, I'm not having that. So there we go. You need to have Ms. Donato come back, and please be sitting appropriately. I don't know where people are learning their behaviors from. And I don't know what she's trying to give off for the rest of the community, but it won't be happening on this Zoom. So if you want to call Ms. Donato and have her Zoom back in and tell her to be seated appropriately, then we will take up that matter. And if she doesn't Zoom back in before 5 o'clock, then the court's ruling will stand.
Will do.
Thank you. Mick Aguilera, you're here?
Good afternoon, Judge. I'm here on an off-docket matter. It's a bond condition for a family violence case. If there's a family violence prosecutor available.
What is your client's name?
Andrea Renee Garcia. Nightmag 614-244.
I'm sorry, give me the NIMAG number again.
614-244.
All right, prosecutors have the ability to move you wherever they want to move you. Joe Ray Garcia and David Barton are here, and if they move you to a breakout room, that means that they're available.
All righty, I'll sit and wait. Hope to get moved.
Okay.
Yeah, I see them both on the screen, but
Oh, somebody closed the breakout rooms? Who did that? Own it. Who accidentally hit close breakout room?
I know it wasn't me.
Here's the thing, people, just own it. Brenda, has it not been a Monday on a Wednesday? But that's okay. When the breakout rooms close, we'll just reopen them. And they're going to close in a few seconds. And Norma, you can let Gomez 14F, let them know he can go back. For some reason, he never left breakout room number 3.
Yes, ma'am.
Rebecca, somebody closed all the breakout rooms and it was one of the co-hosts, but nobody is admitting it.
I know, I saw that. I said, we're closing in 51 seconds, so I'm going to read it as fast as I could.
Yeah. No, so Joe Ray said he didn't do it. Hunter said he didn't do it. Brenda said she didn't do it. Norma will not respond. She's looking bashful.
Judge, I don't have those privileges.
Yeah, I don't have power today, Judge.
Okay, so then that just leaves David Martin. So I'm going to open the breakout rooms back up. And courtroom, I think you can go back to number 1.
Okay, I'm going to join them.
Okay, it wasn't me.
It wasn't me.
All right. Joe Ray, are you able to speak with Mick Aguilera?
I can.
All right, Mick, I'm going to send you to breakout room number 2.
Thank you.
All right, and April Donato, are you seated appropriately?
I am.
All right, then you need to show your video. And Norma, see if you can get someone to zoom in from pretrial services. All right. Ms. Donato. Oh, are you there?
Yes, ma'am.
All right, we have some issues with you. Do you have any idea what those issues are?
Yes, ma'am.
All right, and what are those issues?
I had court, it was reset and it's in 2 days. My bonds probably pushed it up because I didn't check in on Monday. I didn't have a charger for my phone. I just charged it today. And I got all the messages all at once. Everybody was texting me, calling me, trying to get a hold of me. Unfortunately, I was at a location where I didn't have transportation or the correct charger.
No,
I got
that's
the
not
wrong
your issue.
charger.
Your issue is pretrial services say they can't get in touch with you. And this is not the first time that this has happened. How long have you been without a charger?
They have my email and also my phone number.
No, that's not my question. How long have you been without
3
a
days.
charger? I'm sorry,
3
what?
days.
All right, so.
Sunday or Monday.
All right, let me ask you this, and we're not on the record. If you're drug tested today, what are the results going to be?
It'll be clean.
All right, you know you're gonna get drug tested today, right?
Okay.
No, don't do an okay, miss. Now.
I didn't know that.
Yeah, it's gonna happen. So what are the results going to be?
It'll be clean.
All right, I'm gonna make sure that you get your drug test today.
Okay.
Pretrial services is gonna do that. They're zooming in right now.
Thank you.
Judge, I just sent them the link. They'll be zooming in just a few minutes.
All right, thank you. Do you want to, Mr. Myrick, do you want to speak to your client about this drug test?
I'm not in drug court or
Mr. Myrick, do you want to go to a breakout room and speak? I'm sorry, Ms. Donato, what are you saying?
I'm not waiting for a pretrial for a drug case, Your Honor, I don't understand. Is it because she can't get a hold of me?
You are being supervised by pretrial services. Pretrial
I check
services
in.
can and
Yeah,
will
but she
give you a
said-
drug test. No, you have not been checking in with them because I have a document before me that's dated May 21st, and it says they have not been able to reach you. They've been sending text message, contacting your attorney, contacting your bail bondsman. They've called all the numbers that you've given them. Michael Donato, Mauricio Donato. Nobody knows where you are.
I'm checking in with them.
I'm going to
regularly.
send you to a breakout room with your attorney, and your attorney can discuss with you this drug test issue that you're going to be taking.
Yes, ma'am.
I'll send you to breakout room number 3, Mr. Myron, and then we'll come back.
Okay, thank you.
Judge, that's the pretrial officer that's coming in.
Okay, awesome. Just 1 second, everyone. I will be right back. Courtney, are you there?
Yes, ma'am.
Hello, how are you doing?
Good. How are you?
Great. It's what is it, Brenda? Today is a Monday on a Wednesday. But
Yeah,
but you know, it's still a great day. Everybody's great. So,
I feel that.
all right. Are you able to show your video, Courtney?
I mean, I can, but I'm not like, the most presentable right now because I'm just hopping on.
Okay. Do you have like a shirt on?
Oh yeah, I have a shirt on. I'm clothed. I have like, my hair's like not done. I have my bonnet on right
Oh, well.
now. Yeah, I know. That's why I was like, oh, they just messaged me and said that I had to jump on. I was just like, oh my God.
Oh, no.
Because I know how you are. I know how you are, Judge. So I was like, I can't jump on and I'm not presentable and she's gonna get upset.
No, I never get upset. I just, make statements.
Yes, ma'am.
All right. James, your client for some reason stayed in breakout room number 3.
I don't know. I can go fetch her again or
Wait hold on a second. Yeah,
Okay.
she's still in 3.
Don't understand. Okay, well, I can.
All right, yeah. If you could
Excuse
go.
me, Hunter, can you go to breakout room number 1? Ms. Conley wanted to talk to you.
What's going on?
Yes,
If you
James,
can
if you
go to
could go
breakout
grab her, please. And Hunter, you're requested in number 1.
Fantastic.
Oh, all right. Courtney, are you there?
Yes, ma'am.
All right. Ms. Donato, you're here because pretrial services said they've been unable to get in touch with you. And this is not a first time thing. It's a fourth violation in county court at law, number 7, I think. And this is a first violation in here, but you are on bond for an assault, bodily injury, family and household, and burglary of a habitation force out of this court, which is a second-degree felony, and you're not staying in contact with pretrial services. Why can they not contact you? You're muted.
I just have my email and my phone number. I downloaded after when I had your hands on.
Okay, I can't hear a word. I can't understand a word you're saying.
I have regulations on the app, so they have my email and phone number. So I understand why they get a hold of me.
No, this is what they're saying. They have called you at 1, 2, 3, 4 different numbers, and that's what you gave them. They've tried to get you in compliance by sending text messages, contacting your attorney, and contacting your bail bondsman.
Okay,
So
my
why do
attorney
you
has
think
contacted
here's the thing, Ms. Donato, you're on bond
me.
and you have
Bail
conditions
bondsman?
of bond. Why do you think that pretrial services, your attorney, everybody else is supposed to try to hunt you down, as opposed to you
I went to court.
staying
I
in
was in
contact?
court on Friday and I had it again on this Friday, so I don't know why they contacted me. I was there in
This
court.
is you violating your bond conditions with pretrial services. This is
No.
not about you showing up for court late today. This is about you and pretrial services. Pretrial services has been trying to get in contact with you and they cannot. So what I'm trying to figure out is why does pretrial services have to go so far to try to get in contact with you? I'm trying to figure that out, and I'm trying to figure out what is your UA going to be positive for today. Those are the two things I'm trying to figure out.
It's not gonna be positive and I'm not there for drugs. I don't understand. Like, if I went to court and I've spoken to an attorney in court in 2 days,
Courtney?
they can't get a hold of me. Because they have my email and phone number.
Yes, ma'am.
All right, on Miss April Donato, I'm gonna want a drug test. Where can we send her for her drug test?
It's going to be at the pretrial services building. It's going to be at 222 South Comal Street. And yeah, usually they just go up to the front desk, let the officers know that they're there for a drug test. They will pay the cashiers. If she has the fees waived, then she won't pay anything, and then they'll do the drug test.
All right, that's going to be done today. And you're going to get in contact with pretrial services. And you're going to be responsible for giving them your number. So what I'm going to do is I'm going to want her today. You're going to go to 222 South Comal pretrial services, and you're going to have your drug test, and I'll waive the fees so you don't have to worry about paying. But that's going to be done today.
Thank you.
And Courtney, how long will it take for the court to get the results back once you do the drug test?
Usually after the drug test is done, if it comes out negative, then we just, if it comes out negative, then we go ahead and just upload it on their file that it was negative. If it comes out positive, then we submit a form for that. But usually it doesn't take us long to get the results on the UAs. We just have to wait a couple minutes after to get the results.
All right. So what we're going to do is, Ms. Donato, you're going to go today to 222 South Comal to pretrial services. You're going to do your drug test. Court will waive the fees. That's going to be due today before 5 p.m. And you're going to report to pretrial services. With them on the 27th to give them all of your contact information. So today, you're going to pretrial services before 5 p.m. and you're going to give them a drug test. The fees will be waived. And then tomorrow, you're going to report and make sure they have all your contact information. And if they're able to get all of your contact information today, great. But you're going over there to do a drug test today. And this case is coming back on May 28th on Friday. Do you have any questions, Ms. Donato?
Yes, ma'am. I just wonder why he couldn't get a hold of me. If he said, you know, to give him my bail bonds and I should be okay to court, and I went to court.
Okay, this is what I'm wondering. I'm wondering, why do you think that pretrial services has to call 5 or 6 different numbers to get in touch with you? You just told me, unless my memory is fading, and I don't think it is, you told me that you couldn't get in contact with anybody because you didn't have a charger for your phone. So again, we're back to the point of you're on bond for burglary of a habitation force in this court, and you want pretrial services to explain to you why they can't get in contact with you. You just told me you didn't have a charger for your phone. So this is what we're doing. You are going to 222 South Kamal Street for pretrial services to do your drug test. You don't have to pay for it. I'm waiving the fees, and that needs to be done before 5 p.m. today. So what I suggest you do, instead of asking questions, delaying the inevitable, go to Kamal Street and do your drug test. And I will see you back in this court on May 28th. And while you're on Kamal Street, you either need to change your contact information or tell Michael Donato and Mauricio Donato that when they receive messages, they give them to you. That is all. And Courtney, if you can let the court know when that is done, what the results of that UAR.
Yes, ma'am.
All right, James Meyer, we'll see you back here on this case on May 28th at 9 a.m.
We'll be there. Thank you.
Thank you.
Thank you.
Thank you.
Judge, it's Teresa Conley.
Yes, hi.
Hi, you work very hard, lady. Very hard.
Oh, thank you.
Very hard. May I be excused, Your Honor?
Yes, and thank you so much for coming down. Have a good rest of your day.
Thank you, Your Honor. Bye-bye now.
Bye-bye. All right, with that, everyone, we are going to stop live stream, and hopefully Thursday will be a Thursday.